Consular processing versus adjustment of status. What's the difference? There are two pathways that people can take when immigrating to the United States, and these are called consular processing and adjustment of status. Hi, I'm immigration attorney Yael, and in this video, we will explore the key differences between these two processes, what each one entails, and who qualifies to leverage each on their journey to become a permanent American resident. Let's start with consular processing. What is this consular processing? In short, consular processing is the traditional method of seeking and obtaining a green card by those currently living outside the US, usually in their country of origin. And usually it's either based on an I-130 family-based petition or an I-140 employment-based petition. The process is called consular processing because it requires people to go through a US Department of State consulate abroad to apply for what's called an immigrant visa. During this process, individuals will need to wait in their home country until their immigrant visa is approved. Once approved, they can enter the United States as a lawful permanent resident and are able to live and work in the United States starting day one, so from the first day that they entered the US. The actual green card comes in the mail a few weeks after they arrive in the United States. Okay, so that's the process of consular processing. It's just applying for the green card from the consulate in your home country. Now let's talk about adjustment of status. Adjustment of status is the process of applying for the green card and becoming a lawful resident in the United States rather than doing the process in your home country. Okay, and to be eligible to file for adjustment of status, an individual needs to meet certain requirements. Okay, so not everyone can apply for their green card here in the United States. The first requirement is that you have to be physically present or reside in the United States. Okay, you have to be in the United States in order to apply. The second, you must have an approved immigrant petition, either through a family member or an employer. Those are the most common ways. You must have entered the United States legally with a visa, unless you meet some exceptions to that rule. And you must have a green card immediately available to you. Okay, in certain cases also, you must have been maintaining lawful status in the United States in order to adjust your status, unless you're petitioned by an immediate family member. Okay, it could be a spouse, could be a child that's 21 and over, or it could be a parent of a US citizen. Okay, those are the immediate relative categories. If you qualify for adjustment of status, you will not be accruing unlawful presence during the time your green card case is pending. That means that you're allowed to stay in the United States and you can apply for a work permit during this time, which is a really big benefit of adjustment of status. Okay. Now, when you're about to go through consular processing or adjustment of status, it's always good to work with an experienced immigration attorney to help ensure you're handling everything you need for the best possible chance of success. If you would like an individualized assistance, feel free to reach out to us directly. We'd love to review your case and help you out. And if you're interested in more information about US immigration, please like and subscribe to our channel below.